Good morning, ladies and gentlemen. I'm going to divide my talk, which is based on the paper that has been circulated, into 4 parts. Firstly, I will set the scene and summarize some of the key findings that we want to think about this morning. Secondly, I will list some of the key provisions of the Constitution that inform some of these judgments or fail to do so. Then I'll go through each judgment in a bit more detail and make some comments on them. And finally, if there's time, I will make some further comments on some of the key issues that have arisen out of these judgments. Well, to start by setting the scene, the ruling party of South Africa, the ANC, has long been committed, as you well know, to the implementation of a national democratic revolution. It also speaks from time to time about the need to implement what it calls radical economic transformation. In September 2012, the ANC government and many other parties endorsed a national development plan, among whose provisions was that the law should be interpreted and enforced in a progressive and transformative fashion. The aim of this paper, accordingly, is to assess to what extent some of the judgments of the Constitutional Court fall in line with this ideological program. We will look at 6 of them. In the first, the Agri-SA case in 2013, the court held that the assumption of what it called custodianship over private property by the state did not amount to expropriation and therefore did not require compensation. In the second, the Barnard case in 2014, the court held that it was both lawful and fair to leave a senior vacancy in the police force empty rather than appoint a white woman to it. The third judgment in 2016 held that the application of racial targeting in the Department of Correctional Services was lawful, provided that it used the appropriate demographic profile. The fourth judgment, in the FedSAS case in 2016, held that the Gauteng Provincial Education Executive was entitled to override decisions of school governing bodies, that's SGBs for short, about school capacity and enrollments. In the Tshwane case, that's judgment number 5 in 2016, the court rejected an application to preserve Afrikaans street names in Pretoria. In case number 6, the UFS case in 2017, it upheld a decision by the University of the Free State to remove Afrikaans as a key medium of instruction at that institution. So those are the 6 cases in outline. To look at the Constitution itself and some of the key provisions, I will list half a dozen of them. According to the preamble, the document is designed, among other things, to heal the divisions of the past. While Section 9 guarantees equality before the law and outlaws unfair discrimination, it also authorizes measures to promote the achievement of equality. Although the term affirmative action does not actually appear in the Constitution, the measures contemplated in Section 9 fit that description. A rather different concept, broad representation, is dealt with much later in the document when public administration is discussed. According to Section 195, among the principles governing public administration is that it must be broadly representative of the South African people. Property, to come on to that, may be expropriated in the public interest, compensation being subject to certain requirements which are set out in Section 25. And the public interest is defined as including the nation's commitment to land reform, but also to reforms to bring about equitable access to the country's natural resources. The right to public education in the language of one's choice is guaranteed in Section 29. Section 34 protects the right of access to the courts. The rights to equality, to property and education are all dealt with in Chapter 2 of the Constitution, which is often referred to as the Bill of Rights. Various other rights are also dealt with here, and I'll deal with them in detail a bit later, among them socio-economic rights. Chapter 2, that's the Bill of Rights, also includes a clause, Section 36, which specifies when rights may be limited. It concludes with a clause, Section 39, which tells the courts how to interpret the Bill of Rights. So those are the relevant sections of the Constitution. Let's now get on to the judgments. And I will look at each of them in turn and look at the main judgment, but also at some of the dissenting judgments, as well as some of the concurring judgments, which outline different reasons for arriving at the same decision as the main judgment. Number one, the Agri-SA case. In terms of the Mineral and Petroleum Resources Development Act, that's the MPRDA of 2002, all privately owned common law mineral rights disappeared, and all mineral resources were vested in the custodianship of the state. The Act also stipulated that unused old order mining rights should be converted within a year into new rights, failing which they would cease to exist. Accordingly, the issue before the court was whether assumption by the state of the Sebenza Mining Company's old order rights amounted to expropriation. If it did, compensation was payable in terms of Section 25, which, as you no doubt all know, states that property is not limited to land. Litigation started in the High Court and went to the Supreme Court of Appeal, the SCA, before reaching the Constitutional Court, which handed down its decision against Agri-SA in 2013. Sebenza had bought old order coal mining rights in 2001, but had then gone into liquidation and could not afford the costs of conversion. Attempts by the liquidators to sell the rights to another company failed when they were advised that they had ceased to exist under the MPRDA. Agri-SA then procured Sebenza's claim for compensation and brought the case. It argued that the commencement of the MPRDA in 2004 had had the immediate effect of expropriating Sebenza's mineral rights and that compensation was therefore payable. The High Court agreed, stating that Sebenza's rights had been legislated out of existence. This deprivation amounted to expropriation, with the result that compensation was payable as the state had acquired the substance of Sebenza's rights. It made no difference whether the state's competencies were termed custodianship and not ownership. The Minister of Mineral Resources and Energy took the case to the SCA, which set aside the High Court's decision on the grounds that the right to mine was a gift from the state and did not constitute property in the first place. Agri-SA then appealed to the Constitutional Court. The court made it clear that the case was of major political and economic importance. Its main judgment was written by the Chief Justice, Mogoeng. He said that Sebenza had indeed been deprived of its rights, which were now in the custodianship of the state on behalf of the people of South Africa. Whatever custodianship might mean, it did not mean that the state had acquired and thus become the owner of the rights in question. Since the state had not acquired these rights for its own use, it was not obliged to pay compensation. The court added that Section 25, that's the property clause of the Constitution, had to be interpreted with due regard to gross inequality in wealth and land. An overly liberal interpretation could undermine the constitutional imperative to transform the economy. In my view, this main judgment is puzzling. It refers to the need for a fine balance. This is in line with Section 25, which attempts to strike what it calls an equitable balance between those affected by expropriation, the rights affected by expropriation, and, on the other hand, the public interest. In determining the amount to be paid, Section 25 cites 5 factors to be taken into consideration: current use of the property, history of its acquisition, market value, extent of state investment or subsidy, and purpose of the expropriation. Citing this section, the main judgment refers to the constitutional imperative of transformation, to combating gross inequality, and to opening up access to previously disadvantaged people. But nowhere does the Chief Justice explain why these imperatives, as he calls them, preclude the payment of compensation altogether. Far from attempting to arrive at the balance of which he speaks, he simply declares that what took place with Sebenza was not expropriation but deprivation, which he says rules out compensation anyway. Moreover, while this and other judgments, as we will see in due course, refer to the constitutional imperative of transformation, that word does not appear in the Constitution. Furthermore, although the main judgment spoke of the need to create jobs and grow the economy through the expanded development of the mining industry, that industry, as we all know, has continued to shed jobs. One reason is the imposition down the years of various transformation requirements. The economic thinking behind the main judgment has had the opposite effect to the one intended. Indeed, while asserting the importance of developing the mining industry, that judgment failed to take into account the importance of secure property rights in encouraging such development. With the bathwater of property rights, it threw out the baby of mining development. Number 2, the Barnard Case. This revolved around Captain Renata Barnard, a white woman officer in the police, who was denied promotion to superintendent on grounds which she complained were unfair racial discrimination. As I've mentioned, in terms of Section 9 of the Constitution, the state may not discriminate unfairly on grounds of race, except that it may take measures to advance persons disadvantaged by unfair discrimination. Section 6 of the Employment Equity Act of 1998 contains similar provisions, and as I've already pointed out, unlike the Constitution, it defines such measures as affirmative action measures. Miss Barnard had been a member of the police since 1989. In 2005, the National Commission of Police advertised a position for which she was recommended as the best candidate. But she was not appointed to this Level 9 vacancy for the second time around. The Commissioner said that the reasons for not appointing her were that it would not enhance what he called racial representativity at that particular salary level, and that since the post was not critical to service delivery, it was not necessary to fill it immediately. Her case, that's Barnard's case, went from the Labour Court to the Labour Appeal Court and then to the SCA, which found that the Commissioner had failed to show why failure to appoint her was not unfair, and accordingly this amounted to impermissible racial discrimination. According to Dikgang Moseneke, who wrote the main judgment, the core issue in the case was, did the Commissioner's decision unfairly discriminate against Ms. Barnard? At the hub of the dispute was the Police Employment Equity Plan. This plan set numerical goals based on a grid dividing personnel by race and gender on 16 salary levels reflecting national demographics. The judgment said that the Constitution guaranteed equality before the law and that it also prohibited unfair discrimination. However, it also had a transformative mission, requiring active steps to achieve what it called substantive equality. Under the Employment Equity Act, Section 15 of that Act, permissible measures to include this substantive equality include numerical goals, but not quotas. The judgment pointed out that quotas, curiously in its view, were not defined, and then said it would be unwise to give the term meaning. Let it rather suffice, said Moseneke, to observe that Section 15 sets the tone for flexibility, which was the primary distinction between targets and quotas. Justice Moseneke concluded that the Commissioner had not pursued the targets in his plan so rigidly as to amount to quotas. Even though he must have known of what he termed the glowing support from some of his senior colleagues for Ms. Barnard's appointment, there was nothing unlawful in the Commissioner's decision not to appoint her on the grounds that this would have worsened the representativity in salary level 9, where what he called overrepresentation of white women was already pronounced. The police's appeal against the decision of the SCA was accordingly upheld, and its order that Ms. Barnard be paid compensation was set aside. The main judgment also contained 2 warnings. One was that beneficiaries of affirmative action had to be equal to the task at hand. They had to be suitably qualified in order not to sacrifice efficiency at the altar of remedial employment. The second warning was of the need to remain vigilant that remedial measures under the Constitution did not become an end in themselves. Arguably, neither of the warnings has been adhered to. More about that in due course. In the meantime, it seems to me that this judgment epitomizes the tension between the individual right to equal protection and benefit of the law, which is contained in Section 9 of the Constitution, and on the other hand, the notion of substantive equality as expressed in numerical targets reflected of racial demographics, but not defined in the Constitution. Limits on constitutional rights, as I mentioned at the outset, are permitted by Section 36, subject to certain conditions. Among them, that the limitations are specified in a law of general application and that they are reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. Limitations must also take into account the nature of the right, as well as the importance and purpose of the limitation. Nowhere does the limitation clause specify that rights, least of all the vital right to equal protection and benefit of the law, may be limited in the name of the transformation which the court visited upon Ms. Barnard. The DCS case, that's number 3. This was brought by Solidarity on behalf of 10 employees of the Department of Correctional Services, that's the DCS. One of the employees was a white man, the others were colored men and women. Despite the recommendations of various interviewing panels, they were all refused appointment on the grounds that they were overrepresented at the relevant occupational levels. The court, the Constitutional Court, handed down judgment in July 2016. The judgment, in fact, went in favor of the 9 colored employees, but only because the Department of Correctional Services had not used the right demographics in refusing their appointment. Raymond Zondo, writing for himself and 5 of his colleagues, said that transformation, that word again, of the workplace, meant that it had to be broadly representative of the people of South Africa. In terms of the Employment Equity Act, an employer needed to conduct an analysis to identify underrepresentation in the workforce. Numerical goals then had to be adopted to achieve equitable representation. However, In determining the extent of representation, the employer was required to take into account not simply the profile of the national population, but also that of the regional economically active population. This, the Department of Correctional Services had not done. Because it had used the wrong benchmark, it was not possible to determine whether it had been correct in claiming that the colored and female applicants were overrepresented. There was accordingly no lawful basis for determining that they were overrepresented, with the result that failure to appoint them constituted unfair discrimination. Number 4, the FedSAS case. This revolved around admissions to suburban public schools. Who had the power to decide? School governing bodies or provincial officials? FedSAS, that's the Federation of Governing Bodies for South African Schools, whose membership comprises governing bodies of about 2,000 schools, contended that regulations made by the member of the Executive Council, that's the MEC for Education in Gauteng in 2012, were an unjustifiable encroachment on the authority of SGBs because they empowered officials to enforce admissions on schools. One of the contested regulations empowered provincial officials to place learners at any school not yet declared full. Provincial officials were also empowered to determine the enrollment capacity of a school and to declare whether or not the school had reached that capacity. FedSAS argued that these provisions ousted the school governing bodies. On behalf of the court, Deputy Chief Justice Moseneke said, "Public schools are not rarefied spaces only for the bright, well-mannered, and financially well-heeled learners. They are public assets which must advance not only the parochial interest of its immediate learners, but may by law also be required to help achieve universal and non-discriminatory access to education." Panyaza Sufi, the Gauteng MEC for Education, said that the case was a victory for transformation, which finally broke the back of apartheid planning. It would force schools in posh neighborhoods that often claim to be full and deny pupils access to accommodate them. Afrikaans schools, he said, were exclusively white, and it's time for that to change. Mr. Lesufi was also reported to be considering extending the zoning radius from 5 kilometers to 30, so that, as he put it, a child in Soweto will no longer be restricted to apply for admission only at schools in Soweto. He did not want schools that were for Klein Basa alone. In August this year, the MEC published draft amendments to regulations giving himself greater power over admissions to schools at the expense of governing bodies and in determining feeder zones. These, I have no doubt, will be contested. In the meantime, let me simply say, with regard to this case, that Justice Moseneke's statement that suburban public schools should be required to help achieve universal and non-discriminatory access to education is problematic. The fundamental problem with education at school in South Africa, as numerous studies have shown, is the poor quality of the great majority of township schools. And if you compel suburban schools to admit more pupils, that will in fact do nothing to improve the quality of schooling for the vast majority of this country's children. Number 5, the Tshwane street names case. This arose out of a decision in 2007 by the Council of the Tshwane Metropolitan Authority to change 25 of more than 100 old street names. Names that included Hendrik Verwoerd and Louis Botha were to be replaced with names such as Nelson Mandela, Solomon Mahlangu, and Steve Biko. The High Court granted AfriForum an interim interdict against the name changes. This was upheld by a full bench of that court, against whose decision the Council sought leave to appeal. But the Supreme Court of Appeal refused leave. That decision of the SCA was, however, reversed by the Constitutional Court, which granted leave to appeal and also upheld the appeal. Judgment against AfriForum was handed down in July 2016. And essentially, two issues were at stake here. One was whether it was appropriate to grant leave to appeal. The other was whether the cultural rights that AfriForum was claiming were actually protected by the Constitution. The main judgment was written by the Chief Justice, Mogoeng. In granting leave to appeal, he said that the Constitution was about real justice, not mere formalities. Although pre-Constitution common law might have precluded an appeal, the interests of justice were now the only requirement to be met for the grant of leave to appeal. On the second issue, he said that through the preamble and the entire Constitution, we imposed on ourselves a duty to transform. Healing the divisions of the past had to begin by removing from our cities, towns, dorpies, streets, parks, game reserves, and institutions names that exalt elements of our past and cause grief to other racial groups, so as to make way for the heritage and deserving heroes and heroines of the previously excluded. He went on, the Chief Justice did. Nothing that objectively encourages or seeks to perpetuate the stereotypes, prejudice, or discriminatory practices of the past is to be tolerated. Moreover, the Constitution was never meant to be a weapon conveniently produced by some of us only when it could help advance illegitimate sectarian interests through legal stratagems. Two judges, Johan Froneman and Edwin Cameron, issued a minority judgment. Referring to the main judgment statement that the interests of justice now superseded the common law, they said they would refuse leave to appeal on the grounds that correction of the injustices of the past is not best by attenuating well-established and sensible rules and principles for hearing such appeals. The second reason for their dissent was what they said, the implication in the main judgment that any reliance by white South Africans, particularly white Afrikaners, on a cultural tradition founded in history finds no recognition in the Constitution because that history is inevitably rooted in oppression. The oppressive history was there, these two judges said, but the constitutional discountenancing of a cultural history many continue to treasure, they added, has momentous implications for a substantial proportion of the population. Apart from effectively impugning AfriForum's motives as racist, in my view, the court criticized the organization for making use of the Constitution to, quote, advance illegitimate sectarian interests through legal stratagems. And this does not send a reassuring signal to any cultural or other minority seeking to enforce its rights through due process of law to which, as we've seen, the Constitution entitles them. A former High Court judge had this to say of this case, namely that the Constitutional Court had violated an important principle in this judgment. That principle, he said, well established for many years, was that an interlocutory order, such as an interim interdict, was not appealable. AfriForum had raised this point, but it had been dismissed on the grounds that the interests of justice overcame a rule of the common law. This former judge said, although this seemed to be only a procedural matter, a mere formality in the view of the Chief Justice, it was actually more important. Adherence to well-established common law rules created certainty, which was an important aspect of the rule of law. Now to argue that the interests of justice trumped common law opened the way to the intrusion into the law of the subjective preferences of judicial officers. 6, the University of the Free State case. That turned upon the downgrading of Afrikaans at the University of the Free State, where English was now to be the primary medium of instruction, with Afrikaans to be used only in special circumstances. AfriForum and Solidarity unsuccessfully went to the Constitutional Court for leave to appeal against an SCA decision in favor of the university's new language policy. With 7 of his colleagues concurring, the Chief Justice said that South Africa's, quote, young constitutional democracy needs as much litigation as possible for the divination of hidden meanings of unclear yet crucial constitutional clauses and concepts, whatever that may mean. However, he also said that granting leave to appeal in this case would be an injudicious deployment of scarce and already overstretched judicial resources. On the merits of the case, he said that apartheid was a crime against humanity. This was the essential context of the case as he described it, and Afrikaans had been used as an instrument of control, exploitation, and systematic humiliation. The language is now being phased out as a medium of instruction to advance a constitutionally inspired transformational agenda. The question was whether it was reasonably practicable for the university to retain Afrikaans as a second major medium of instruction. In deciding this issue, the Chief Justice said, "We must all consciously guard against the possibility of a subliminal and prejudicial disposition towards Afrikaans. Judicial officers should never be emotionally entangled in matters presented for their determination." As already noted, language rights in the educational sphere are set out in Section 29(2) of the Constitution. Everyone has the right to receive education from a public institution in the official language of their choice, where this is reasonably practicable. The meaning of this phrase, said the Chief Justice, lay at the heart of the application. Although it might be practicable to retain Afrikaans as a major medium of instruction, it could not be reasonably practicable when race relations were poisoned thereby. Had race relations been poisoned, the main judgment said, well, the university would be in a position to know. In a minority dissenting judgment, Johann Froneman and 2 others said they would have granted leave to appeal and not refused it. The main judgment, they said, had accepted the university's assertion that it was impossible to provide education in a language of choice without discriminating on the grounds of race. This, in their view, was a step too far. On the papers submitted, there was no suggestion that all, most, or even a substantial proportion of white Afrikaans-speaking students who were being taught in that language had been guilty of racial discrimination. These students, these 2 dissenting judges said, had been deprived of a right and had a sanction visited upon them without evidence that they had been guilty of racial discrimination. Writing for this minority, Justice Froneman then said he would have referred the matter back to the High Court, in which the case had originally been heard. The university would then be able to present evidence on the nature and extent of any discrimination by students or lecturers using Afrikaans, the disciplinary or other measures that had been taken to address these acts of racial discrimination, and, if not, why not? At the same time, back in the High Court, AfriForum would then have been able to present evidence on practicable alternatives available to continue parallel medium of instruction that would not result in indirect discrimination. It seems to me that even though the Chief Justice warned against what he termed emotional entanglement and prejudicial attitudes towards Afrikaners on the part of judges, the main judgment was free of neither. A few further comments, my final section, on 2 of the cases. Firstly, property and other rights, and the Agri-SA case. This case saw property rights subordinated to the constitutional imperative to transform our economy. Section 36, as I've mentioned before, specifies factors according to which constitutional rights may be limited. The need to implement a transformation imperative is not one of these factors. Also, as already noted, Section 39 of the Constitution says that in interpreting the Bill of Rights, the courts must promote the values that underlie an open and democratic society based on human dignity, equality, and freedom. They must also consider international law, and they may consider foreign law. Nowhere in this section are the courts told that they must also consider transformation imperatives, or even that they may do so. In claiming that the Constitution contains such imperatives, the Constitutional Court is putting words into its mouth, and this is a step too far. It is also ominous. If property rights can be attenuated by saying that an overly liberal interpretation thereof undermines transformation, then this contrived transformation imperative can also be used to override other constitutional rights on the grounds that they should not be interpreted too liberally either. Far from stoutly defending constitutional rights, arguing one of its most important functions, the Constitutional Court has opened the way to undermining them. Although the Constitution proclaims itself to be the supreme law of the Republic, the Constitutional Court seems to be saying that the transformation imperative, as adopted and interpreted by itself, is actually the supreme law. To say a bit more about the employment equity question and the Barnard case. Once again, the Constitutional Court referred to the transformative mission of the Constitution, this time with the intention of promoting substantive equality. But the Constitution makes no reference to substantive equality. The legislative measures to advance the disadvantaged and the principle of broad representation, which is contemplated in the Constitution, have somehow been transformed by the Constitutional Court into equitable representation and substantive equality to be measured by racial demographics. And that is quite a big jump. It's a pity, I think, that the Court did not deal with the issue of whether the Employment Equity Act was possibly unconstitutional in turning broad representation into equitable representation in all occupational levels according to numerical goals. If it's possible to find a material difference between a target and a quota, perhaps there's also an equally material difference between broad representation and equitable representation. If discrimination is fair to achieve a target but not a quota, then perhaps discrimination is fair when it pursues broad representation, but not fair when it pursues equitable representation in all occupational levels to be measured by racial demographics, whether national or provincial. Has its belief in this constitutional imperative of transformation caused the Constitutional Court to give excessive weight to the concept of broad representation? The section of the Constitution, I've already referred to this, which deals with public administration, section 195, does not give priority to broad representation. It stipulates that employment practices should also be based on ability, objectivity, and fairness, while efficient, economic, and effective use of resources must be promoted. That's section 195. Section 196 charges that the Public Service Commission has the task of maintaining effective and efficient public administration. As I mentioned, the main judgment in the Barnard case warned that beneficiaries of affirmative action had to be equal to the task at hand. They had to be suitably qualified in order not to sacrifice efficiency and competence at the altar of remedial employment. The minority judgment said that the quality of public bodies should not be sacrificed to achieve representativity and redress past disadvantage. Arguably, however, implementation of representativity targets has been among the factors undermining the quality of services provided by public bodies. In conclusion, then, while transformation in the pursuit of employment equity has overridden the rights to equality of racial minorities, it has also helped to undermine other constitutional rights to the detriment of a great many more people. These rights, set out in the Bill of Rights, include the right to life, the right to dignity, the right to security of the person, and the right of access to housing and health care. Enjoyment of these rights, the so-called socio-economic rights, depends on numerous factors, of course, but among them is effective and efficient performance within the public sector, as stipulated by Section 196. Section 195, as we've seen, requires public administration to be development-oriented and to use resources efficiently, economically, and effectively. Yet for at least a decade, the public service has confronted South Africans with crumbling infrastructure, dysfunctional municipalities, unreliable water supply, malfunctioning sewerage systems, poor policing, dangerous rail services, and dirty hospitals. The dysfunctional state has undermined numerous provisions of the Bill of Rights. The damage inflicted upon Eskom and by Eskom has helped to undermine economic growth and therefore the ability of the economy to create jobs. We could go on about the dysfunctional state all morning, but there's no need to. Along with cadre deployment, the manner in which the government has run public administration has clearly regarded the pursuit of racial representation as more important than the other objectives stipulated by the Constitution. And the Constitutional Court, in my view, has echoed this mistake in its view that racial transformation is the overriding imperative of the Constitution. And the whole country, in fact, has paid a very heavy price. Thank you.